Hi everyone. So today we're going to look into statutory interpretation. So if you want to get a basic idea how statutory interpretation works, I just want you to travel back in history just for 2 years. In 2018, Sri Lanka faced a constitutional crisis. It was a legal deadlock which lasted for about 7 weeks, and due to the intervention of the Supreme Court, the Chief Justice of the Supreme Court, he interpreted the 19th Amendment in such a way and said two things, that the president needed the referendum of the people and also required two-thirds majority to do perform certain functions which he needed to do. So this shows when a country is in chaos due to legal trap and confusion about the legal provisions and powers of the president, the Supreme Court interpreted it in a particular manner and they gave a solution. Whether we like it or not, they have given their interpretation. So this shows how the statutory interpretation plays a major role not only in our country but all around the world to overcome the legal disputes. Most of the courts are doing this. So this is very good if you get a hold of this subject. It's very fascinating that every lawyer, judges especially, and legislative drafters and politicians, many people should use this in, and as aspiring lawyers, we would also want to use them in our future. But first of all, in order to be lawyers, we have to pass our exams. And in our legislative drafting exam, this part, the statutory interpretation, and especially the rules which we use to interpret statutes, play a major role, because most of the recent papers, especially the first question, the compulsory 20 marks question, it comes from this part, especially traditional rules. I will explain them what traditional rule means. So you should understand the significance of this statutory interpretation, because the recent papers in 2019, 17 and 18, they have the first question from this part, and the last two questions are also come from the specific part which we are looking today, that is statutory interpretation. First, I would like to clarify that statutes are acts passed in the parliament. You might know, you should know. And if you didn't know about the constitutional crisis, you should be politically savvy in future, because uh, all of this would be helpful to get an understanding how law works. So statutes are the future. The 21st century is the century, and in the future, statutes would overtake the importance than the common law. Common law is case laws, but we have case laws even in our statutory interpretation lesson. So we will look into that. Interpretation is a rational and an intellectual activity. Statutes are made to make us easily interpret, but there are certain times where there are ambiguities and confusions might arise due to words can have different meanings, it can have contradicting meanings. So you should be able to interpret it in a useful and a productive way. So we have rules for that. You should first of all understand that the function of this statutory interpretation is to give effect to acts passed in a parliament. It can be also treaty and non-treaty legislations. So we want them to be given effect through our interpretation. So we will look into the classification. Basically, when we classify, there are two things. Traditions, old customs, the basic rules which were followed in the past, and the modern rules. So if we want to know about traditional rules, the traditional rules are classified further into three: literal rule, mischief rule, and golden rule. Then the modern rules are divided into purposive rule and dynamic rule. There are a lot of rules. You might be confused, but I would break down and clarify everything. First of all, we would like to talk about the traditional rules. And in the traditional rules, the first is the literal rule. Literal rule is very simple. as you and me, everybody can do. It's easy to practice because it's just getting the literal meaning out of a statute. You read the statute, understand the words, and get the idea. So, Antonio Scalia, a former US Supreme Court justice, so he was a great legal advocate for this literal rule. So he had mm, given more importance to it, but it can be used, literal rule can be used in interpreting certain areas of statutes. But when we will look into where the pros and cons, the merits and the demerits, because everything has two sides. So now we will look into a good example, R versus Harris case. So in the R versus Harris case, it's a case where a person attacked another person. He bit a person in the nose. It's quite funny. But they could not convict the attacker because the statute for says you should, if you're attacking a person, it should have been an unlawful malicious stab, cut, or you should have wounded any person. But it doesn't mention specifically about biting because they had left it out. So the courts were unable to convict the attacker. So this shows where literal rule has some disadvantage also. But we will look into the both sides. Now, there are some case laws like R versus Judge of the City of London Court and Felix versus Thomas. So these cases, they applied the literal rule. The courts applied the literal rule. What is the Felix versus Thomas case? Simply says there is an ordinance where it offends, like certain offenses are listed, and it says you cannot perform these or offenses in a place, and the statute says in any public place. So in a public place doesn't mean that you can't interpret it as in any place. The court went to interpret it as the literally it says in only public places you cannot perform these particular offenses according to this ordinance. But you can't interpret it as everywhere, any place. If it's quite confusing, I'll like to clarify it. That means literal rule says the exact words. You have to follow the words crystal clearly in the statute. It might cause some absurdity and unreasonableness. And sometimes the statute was might lose its purpose also. But unfortunately, the courts cannot do anything about it. It's the mistake of the people who made the lawmakers. So the court cannot rectify those errors or loopholes or unclear vagueness caused in the statutes. They just directly get the meaning out of the words. And there are certain cases in Sri Lanka, like Mushin's case, Stetson Exports Limited versus Brookbone case, and Somanvadi versus Veerasinghe case, which is a fundamental rights case. So everybody in these cases, the courts followed the literal rule. Now I will look into list out the demerits and the merits. If you go to the brighter side, merits, the advantages of these rules, as Antonio Scalia, who always brags about, is that certainty. The law is certain, it's consistent, and the courts will be neutral. They cannot be biased when you use this literal rule. They are neutral. And you should give respect to the theory of separation of powers, and the sovereignty of the parliament is upheld through this literal rule. So these are certain advantages. You have to know about them. So what are the disadvantages? It's quite easy. I even looked it in the R versus Harris case that it can lead to absurdity, unreasonableness, but these are harsh consequences we have to face when we literally interpret by this literal rule. And you should know, like, interpretation is not just giving meaning to words, it's further beyond that. We will look into it how in the other rules. And literal meaning is it's giving a tight case like enclosure, that the judge cannot be creative. He is stuck in a box, he cannot think out of the box. So that's another problem. And then we would also go like words don't have always one meaning, it can have a secondary meaning. So that causes some confusion, and it might lose the purpose, the statutes might lose their goal. So it can not serve justice at some times, not always. So now we looked into the merits and the demerits and some few case laws. So literal rule is simple, as I say, that everybody, a layman even, can understand what literal rule is because it's just reading and getting the direct meaning. But now I would like to go into the mischief rule. Mischief rule is quite interesting, and here it's what it tries to say is, if the common law is not perfect, there are some uh, mischiefs and some errors can occur in the common law. So the court has the duty to suppress this mischief. They have to prevent this mischief by passing acts or statutes. So that is what mischief rule does. For example, I would like to clarify through an interesting story. Misfits go to the prostitution. So prostitution is illegal in London city, and they wanted to eradicate the problem because commoners and general public were embarrassed, or they were harassed by prostitutes who were trying to solicit customers in the public area, public spaces. So they passed laws, statutes to ban prostitution. And the statutes specifically stated, in a street, you cannot, prostitutes cannot try to get customers. So they went into the houses. The prostitutes tried to solicit or attract customers from the balconies or from the windows. Then the courts got into the statutes and they interpreted it. So this is a mischief. This is a problem in the society. Like in the London in the 20th century, they wanted to stop prostitution as a whole. So they understood, in order to suppress this mischief, they will have to interpret the term in a street as, even though the prostitutes were in a building, in a balcony, or in the window, those activities of attracting customers from inside those places is also completely banned. So that is the way mischief rule is interpreted. There's a problem, and there's a common law has a mischief, is given a way to a mischief, and an act is passed by the court to suppress this mischief, and the courts interpret it in a way so that the problem is solved in overall. They don't want it to continue. Even in Sri Lanka this happened. You might have heard about brothels ordinance. It is a quite similar case. Here also the brothels ordinance intention was to prevent prostitution and stop it. But there was an interesting case in PETA, a tailor shop, where actually there was no prostitution occurring in the tailor shop. The case is called Dorothy Silva versus Inspector of Police, PETA case. Here Dorothy Silva, what he was doing was that he was giving photographs of the prostitutes, and he was acting as a broker and third man. So he was the intermediate man who was connecting the prostitutes and the customers at his tailor shop, and they would perform the activities in a hotel. So the police were in a way that they wanted to prevent this prostitution, so they filed a case. So the courts were handling this problem. They knew the purpose of this brothels ordinance is to eradicate prostitution. So as a result, they took mischief rule and interpreted in a way, although Dorothy Silva's tailor shop had nothing to do with prostitution directly, but it had some indirect connections. So they just took the stance of the police and they sealed the place. So this shows how mischief rule plays a role, and Hayden's case in the 1584. This case gave birth to mischief rule. But mischief rule will not end here only. It would come to us in a more evolutionized form in the future in the modern rules also. We will look into that later. Now we saw traditional rules, literal rule, mischief rule, and the last is the golden rule. So what is the golden rule? Golden rule is simple. If you interpret a statute in a literal rule and if it leads to unreasonableness or uncertainty, so what we do is we disregard the literal interpretation of the statute. That's what the golden rule does. It does not take this literal meaning if it is causing absurdities. For example, there are some case laws which look into this. Foreign cases like Adler versus George. So in Adler versus George, what happened was there was an act in the UK, Official Secrets Act. The act, in that act, a statute, it says if people who are not allowed in particular places, public are not allowed due to security reasons. Only authorized personnel are allowed inside a particular area and particular buildings due to security and national security reasons. So what happened was, in this Adler versus George, the statute clearly states if any person is lingering or is around in the vicinity of any unauthorized place, like if the person is not allowed in the vicinity, he is can be punished through this act because they suspect this person who committed the crime as a spy. So the problem here was, when you literally interpret it, the person who committed the crime should be in the vicinity of a building, in the vicinity, that means in the surrounding of a building where he is not allowed. He should not be there in the surrounding, but in this particular case he was inside the building, which he should not be there. He is an unauthorized intruder. So the court got took they interpreted in according to the golden rule and said, although the statute says in the vicinity, it can also mean inside that building, and they punished him for spying. Similarly, Corocraft versus Pan American Airways, even in this case the golden rule was adopted to interpret the statute in order to give meaning to the legislature, because at sometimes if you use literal rule, it can cause absurdities. So golden rule prevented those absurdities and they interpreted in a way that it is useful and gives a productive way, and it gives justice so that justice is served. There are certain Sri Lankan cases which are quite interesting, such as the Billion Bay Apparel case and the Vikramaratne versus Mendes case. So these two cases, what are they trying to say is these local cases, Billion Bay Apparel case and Vikramaratne versus Mendes case. In these cases, golden rule was used to interpret, because these cases highlight that the court said at certain point there can be negligence or some careless, reckless, small technical problems when you file a case. For example, in the Vikramaratne versus Vikramaratne versus Mendes case, the problem was the lawyer had failed to mention his name and some certain technical negligence was there. But the courts did not reject his case or reject the appeal, because they knew this was his due to his negligence and slipshod attitude. But that doesn't mean that the appeal can be repealed. The appeal cannot be neglected. So what I'm trying to say is golden rule gives way to serve justice when the literal rule just neglect at certain point, then it cannot serve justice because it is uh, not getting what the purpose of the statute is. So golden rule is used to fulfill the parts where the literal rule cannot do. And now I would like to clarify. Now the traditional rules, the literal rule, mischief rule, golden rule. So these are the three rules and how the case laws worked. Now we will look into the modern rules. What are the modern rules? So there is evolution, law changes. So as a result, the modern rules are formed when the law changes. For example, we know there are two modern rules, purposive rule and the dynamic rule. So purposive rule is a result of evolution of the mischief rule. What is the difference? It's quite similar. In a mischief rule, if there's a mischief, we have to suppress it. In order to suppress that, we use statutes, acts. But here in the purposive rule, external aids are used in order to resolve those problems, those mischiefs. So the mischief rule is the forerunner for the purposive rule. And in the similarly, dynamic rule is also related to the golden rule. The golden rule is the forerunner of the dynamic rule. Due to evolution, it had changed. And now we use them as modern rules. Especially Aaron Barak, Chief Justice of Israel, he was advocate for the purposive rule. So he was saying that purposive rule is the ultimate rule of the future. So he classified purposive rule into two. That means subjective dimension and objective dimension. I will just clarify it. That means Aaron Barak says that if you're going to interpret according to purposive rule, you can use external aids. So when you're interpreting the statutes according to subjective dimension, you can use or refer Hansard, law reform reports, parliamentary committee reports, green papers, white papers. These reports can be used. But if you're going to do the objective dimension, there are certain human rights standards and constitutional standards and transitional rights. So these rights and these standards can be referred when you're interpreting objectively, and in subjectively you can refer these extrinsic materials such as the Hansard, as I mentioned before. Now we will look into the landmark case, Pepper versus Hart. Pepper versus Hart was a simple case. There was a teacher who taught in a private school. His two children studied in the same school, so his children's school fees was deducted. Now the tax officer wanted to tax him for the deduction in their in their school fees. Simply the school fees was deduced because he taught in the same school. His children were in the same school. Now this case led to uh, the courts. The courts were trying to interpret it using purposive rule. So what did they do was they wanted to know the purpose of the what do you call the ordinance, they wanted to know why the tax rules are passed and what was the intention of the tax rules, whether the tax rules or the statutes, they really wanted to target this particular teacher. So they told the courts for the first time in the UK's common law history, they referred the Hansard. If you don't know what is a Hansard, I'll just explain. Hansard is where a document where they record everything what happens in the parliament, especially the speeches where the MPs give before they pass bills or enact bills or pass acts. So these speeches, the statements made by the MPs, everything is recorded. So in the Pepper versus Hart case, they wanted to look into the Hansard and understand the purpose of the tax bills. And then they realized whether the taxation of this particular teacher was fair or not. And this is how purposive rule works. They look into extrinsic materials. Now I would like to go into a case in the Caribbean. So you might have known about the European Union. It's common, like all these countries work together. Similarly, all the Caribbean nations have a pact. So it is called the Chaguarama Act. So what you don't need to know the treaty. The treaty's name is Chaguaramas. But the treaty gives provisions where all these Caribbean countries they work together to inter-regional to the benefit of each other symbiotically for the intra-regional trade. So there are tax breaks for companies and so on. Now in this treaty there's a special article 222. So why am I talking about this case? This is the Trinidad Cement Company Limited versus Attorney General of Guyana case. In this case, the question was whether a juristic person vindicate for their rights against a member state, such as Guyana is a country. So this particular company wanted to file a case, uh, vindicate their rights against a member state in the Caribbean community. They had a problem whether this was allowed or not, whether this is possible or not. So that the courts, the Caribbean courts, they used the purposive rule here and they interpreted it and they said it is possible that a juristic person can file, who has a locus standi, can file against a member state. If you want to, if it's a little bit confusing, I can simplify more easily. There's a Sri Lankan case, Sriani Silva versus Inda Malgoda. In this case what happened was, we are referring to article 126 in our Sri Lankan 1978 constitution. So and especially the subsection 2. In the subsection 2, if a person wants to file a fundamental rights case, the person who is affected, imprisoned unfairly, who is affected, can only is given provision to file a fundamental right case. But this is a unique case where here the person who was affected was not in a situation, the aggrieved person is not in a situation where he can institute a case, because as a result his wife came forward instead of him. So here Justice Shirani Bandaranaike, she saw uh, the real problem and analyzed the practicality, and she applied the purposive rule instead of the literal rule. As a result, justice was served for the affected person. Now, what we are trying to say is purposive rule gives more clarity and gives the purpose. When statutes are created, there is a particular purpose. So, in order to fulfill or overcome that purpose, purposive rule uses extrinsic aids, especially Hansard's and human rights standards, and they consult those standards. So these are used in order to fulfill the purpose of this purposive rule. Now we will look into dynamic rule. Dynamic rule is, as I told before, is the forerunner of the golden rule. Dynamic rule can be separated as when you interpret statutes. So dynamic rule is used to interpret the constitution, interpret human rights legislation, and also to interpret treaties. Now I would like to focus on constitution especially, because modern rules are very well applicable to the constitution. Even Antonio Scalia, a person who advocates for literal rule interpretation, the traditional rule which we talked in the before, that person itself, he itself stated that traditional rules will not be suitable to be used to interpret the constitution, because modern rules are more preferred. and they give more meaning because the constitution is a living document. It goes through a lot of changes, amendments, like the 19th amendment. So if you take in Sri Lanka, the Sriani Silva versus Indamalgoda case, it is a good example where Justice Shirani Bandanakar used both the purposive rule and the dynamic rule to interpret the statute. I mean, so the article, especially Article 126, you can look into it. And there's a 13th Amendment case. You would learn in Constitution there was a case for 13th Amendment and Queen versus Leonege. These are local cases where they used dynamic rules to interpret the Constitution. So there are foreign cases also, like Brown versus Board of Education, which eradicated the segregation in America, racial segregation in America, and Roe versus Wade, which is a landmark case for abortion. So these cases show a good example where the courts used dynamic rules. So dynamic rules were used to interpret the constitution, and dynamic rules can be used also to interpret human right legislations. For a good example is the Theo versus Minister of Immigration in Australia. What happened was Theo was an Indonesian by origin. He was an illegal immigrant in Australia, but he had a family in Australia. He had uh, two children. So now the problem was the Australian government, as everybody knows, they are strict in their migration laws. They wanted to deport him. But the Supreme Court overturned the High Court because the High Court did not consider the condition of the two children of Theo, the person. So the Supreme Court saw the rights of the child convention. They were more focused on the child's well-being, children's well-being. So they interpreted the statute in such a way so that they would not deport Theo. But unfortunately, not all judges or all courts prefer the dynamic rules. At certain instances, such as the Singharasa case in Sri Lanka, they Chief Justice of Sri Lanka at that time did not want to give interpret using dynamic rule. He did not consider human rights standards. So it depends upon the courts. So what we're trying to say is dynamic rules play a major role, and they are used as judicial activism, as that's a new way of approach. Like the justices and the courts are trying to solve the issues in the statutes, the vagueness, the uh, the problems or the loopholes in the statutes are being cleared through the modern rules, especially purposive and dynamic rules. So overall, what I'm trying to say is these rules are used to interpret statutes. So you should know how these rules work, what are the case laws that are important, and what the rules mean and how they are applied. So I think you might have got a very brief and understanding about what statutory interpretation is and what are these rules. So if I want to recap again, statutory interpretation is divided into two: traditional rules and also modern rules. You should know the traditional rules are classified further as literal rule, golden rule, and mischief rule, and the case laws and how it works. And you should know in the modern rules you have the purposive rule and the dynamic rule. So these rules are helping legal professionals to interpret statutes in a meaningful manner so that justice is served for everybody and they try it to their maximum. So I hope you got some understanding about statutory interpretation and you realize the significance and importance of this subject, and you should go through it thoroughly, especially the lecturer's notes and the union notes in order to understand and do the questions. In the end, everybody, we have to pass the exams. So I wish you all the best, and we hope you understand, uh, you got a proper understanding about this topic.